Welcome to our update on Special Immigrant Juvenile Status, or SIJS. Today we explain the federal judge's order restoring deferred action protections for many SIJS youth, what that means for stability, work options, and case processing, and the critical risks you still need to consider. First, we'll cover what SIJS is. Next, we'll outline the ruling's impact. Then, we'll compare deferred action and work permits, walk through action steps, and finally flag key warnings and a legal disclaimer. Let's begin. Here's our roadmap. We start with a quick SIJS refresher. Then we explain why the ruling matters. After that, we clarify the difference between deferred action and work permits. Next, we move to practical steps you can take now. Then, we discuss risks, potential appeals, and agency compliance. We will include 2 brief quizzes to reinforce your understanding. Finally, we end with key takeaways and a legal disclaimer. Special Immigrant Juvenile Status is a humanitarian pathway for minors who have experienced abuse, neglect, or abandonment. It requires a state court finding that reunification with one or both parents is not viable due to those circumstances, and that it is not in the minor's best interest to return to their home country. SIJS can lead to lawful permanent residency, but benefits are discretionary and do not extend to parents. Processing can be slow, and interim protections like deferred action can be crucial. The court's order restores a critical safety net by reviving deferred action for eligible SIJS recipients. This means the government agrees not to deport certain individuals while their broader immigration matters continue. As a result, many can reapply for protection and seek employment authorization while their cases are pending. The ruling also urges agencies to restart stalled case reviews, offering much-needed momentum. In turn, this stability can help maintain school enrollment, work continuity, and emotional well-being. Now let's transition to a common point of confusion: the difference between deferred action and work permits. This timeline illustrates the policy swings. First, deferred action was available. Then came a suspension that created uncertainty and risk. After that, litigation sought to challenge the disruption. Next, the judicial order restored deferred action. And finally, agencies are expected to resume case reviews, though the timing is unclear. Looking ahead, appeals could delay or reverse protections, so applicants should act promptly while protections are available. It is essential to distinguish between deferred action and employment authorization. Deferred action is a discretionary decision by the government not to deport you. It is temporary and can be changed. In contrast, a work permit, also known as an EAD, requires filing Form I-765 under an eligible category and receiving a separate approval. SIJS recipients may qualify for employment authorization, but a court order restoring deferred action does not automatically produce a work permit. You must file, track adjudication, and wait for a decision. Now let's move into practical steps you can take right away. Proceed methodically. First, confirm your eligibility and ensure your SIJS status, age, and state court findings are in order. Next, consult a qualified immigration attorney or accredited representative to assess your options. If you are eligible, reapply for deferred action without delay. If you need to work and qualify, file Form I-765 for employment authorization and include the required evidence. Meanwhile, compile identity documents, SIJS approvals, and relevant court orders. Then, set alerts to monitor your case and any agency announcements. Additionally, prepare a contingency plan in case an appeal changes the legal landscape. Finally, make sure your address is current with SIJS and any court to avoid missing critical notices. At present, eligible applicants may benefit from restored deferred action, reapply for protection, and pursue employment authorization, while agencies are expected to resume case reviews. However, if the government appeals successfully, protections could pause or be reversed, leading to delays in agency compliance and uncertainty around work permits and renewals. Therefore, it is essential to maintain a proactive plan with your legal representative to adapt quickly to changes. This pie chart is purely illustrative. It shows 4 conceptual possibilities: a full restoration path, delayed compliance, protections stayed during appeal, or a policy rollback. The equal slices emphasize that we are not predicting probabilities, only visualizing distinct scenarios you and your attorney should monitor. Use this framework to stress test your plans under different outcomes. There are 3 central warnings. First, the appeal risk. Higher courts, including circuit courts or even the Supreme Court, could modify or overturn the ruling. Second, compliance uncertainty. Because the order lacks a specific timeline for action, agencies may implement changes slowly, leaving applicants waiting. Third, do not confuse deferred action with a work permit. Deferred action is a decision not to remove you. It does not automatically grant work authorizations. Applicants should remain vigilant and responsive as the situation evolves. This table lists key documents and tools. The State Juvenile Court Order provides the findings necessary for SIJS eligibility. AUSCIS approval of the I-360 confirms the SIJS classification. Form I-765 is used to apply for a work permit and is not granted automatically. It requires supporting evidence. Government identification documents are necessary to establish identity. The AR-11 is used to update your address with USCIS. Finally, a USCIS online account lets you track your case status and receive updates efficiently. Quiz time. Which statement best describes deferred action compared to a work permit? Option A. Deferred action automatically includes a work permit. Option B. Deferred action is temporary protection from removal, while a work permit requires a separate application and approval. Option C. A work permit is the same as deferred action. Option D. If you have SIJS, you never need to apply for an EAD. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. Deferred action is a discretionary, temporary protection from removal. A work permit requires a separate application, Form I-765, and an approval. They are distinct processes, and one does not automatically guarantee the other. Second quiz. Did the court set a specific deadline for agencies to comply with the order? Option A. Yes, 14 days. Option B. Yes, 60 days. Option C. No, the ruling did not set a specific time frame. Option D. Yes, 90 days. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. The court did not impose a specific time frame for agency compliance. This creates uncertainty and underscores the need to track developments closely and proceed without delay. Here are the key takeaways. First, deferred action is restored, so act promptly to take advantage. Second, employment authorization requires its own application. Third, while agencies should restart reviews, there is no set timeline. Fourth, appeals may alter or halt protections, so create a backup plan. Fifth, maintain close contact with a qualified immigration attorney or accredited representative. Important disclaimer. This content is for general informational purposes and is not legal advice. Immigration outcomes depend on individual circumstances. Consult a qualified immigration attorney or accredited representative for guidance tailored to your case. Policies and interpretations can change rapidly, and court decisions may be appealed, stayed, or reversed. To summarize, SIJS remains a vital path to safety and stability for vulnerable youth. The judicial order restores deferred action but does not automatically grant work authorization, so apply separately if you qualify. Move quickly, gather documentation, and closely track your case. Anticipate uncertainty around agency timelines and prepare for potential appeals. Throughout, coordinate with a qualified legal professional. Thank you for watching. If you found this helpful, please like, share, and subscribe. Tell us in the comments what questions you have, what you are seeing in real time with agency processing, and what topics you want next. Your feedback helps others find reliable information.